Time now for Sports and the Law. The trial in sportscaster Erin Andrews' lawsuit against Marriott Hotels continues. Andrews is suing Marriott for $75 million in damages over a video taken of her in her room and displayed on the internet. She claims she suffered mental and emotional abuse. This trial's been going on for a little over a week now as we welcome you into Sports and the Law with Steve Moskowitz, our Sports and the Law expert. I know we touched on this a little bit last week, but now we're starting to get more and more details. I want to start with her emotional state. On the stand, she was extraordinarily emotional. How does that play with the jury?
Jury's human, emotional. I mean, it looks like she's really suffered.
All right, so Andrews said in her testimony that her employer at the time, Espn, they not only requested, they made her do an interview in which they said, and she had to say this was not a publicity stunt. How bad does that look if your employer is trying to distance themselves from something?
It makes sense because otherwise somebody could have wrongly thought that she put those pictures up or that she had somebody post it for publicity. So she's the victim here. I want to make that very clear. So
ESPN helped her in doing this because the way she termed it was, boy, ESPN kind of made me have to go out and do something. She eventually did something with Oprah.
First of all, she was embarrassed about it, obviously. But again, from the station's point of view, they want to say, look, our people don't do that. She was a victim here. She didn't post this.
All right. On Marriott's side of this puzzle, their defense is that Erin Andrews' career benefited. How dangerous of a defense is that?
Marriott is really making a big mistake because what's happened is, and both sides, she's asking for way too much. She's not going to get 75 mil because in a death case, maybe you get a couple of mil. So she's a star, maybe she get 5. If I was representing Marriott, I'd say, guys, you are buying yourself way more than 5 mil of bad press. And if I was the judge, I would order him into a room and say, you guys mediate for a while, work something out. That's what should be done. It should be worked out. Clearly, Marriott was at fault here, but not 75 mil worth.
Is that somewhat of a common defense that Marriott is taking, or is it a cheap shot and really a bad, I know it's a bad decision, but kind of a Hail Mary type?
It depends who you ask, but the problem is something like that can inflame a jury and make the damages worse.
All right, let's move to our second story. This has to do in football. Jason Pierre-Paul of the New York Football Giants, he's suing ESPN and their football writer Adam Schefter after ESPN he works for ESPN. He was posting pictures of a medical chart with descriptions of Pierre-Paul's injured fingers on social media after a fireworks accident. Pierre-Paul missed the first 8 games last year, played the final 8 games, didn't quite play as well. The suit is an invasion of privacy lawsuit. How affected is it by the fact he's a public figure when this was put out?
That's one of the things, and also he's going to have difficulty pointing a finger at him because what's happened is he's already settled with the hospital. They're the wrongdoers, but the bottom line is with a newspaper, and this goes way back to when we were small boys with Watergate, when the Supreme Court said if it's newsworthy, you can print it. And here, the guy is a public figure, and everybody knew about it. The guy that would have a case is the other fellow that was on the bottom of the sheet. If he wanted to sue, he could, but he probably got paid off.
How different is it with social media, the social media age? Before you could print it, or you saw it on one of your 3 TV channels on the evening news, but you didn't have a lot of other sources. Now, you and I could have a website, and we just take a picture, and boom, we're throwing it up there.
Absolutely, and that strengthens the case for the defendant, because the thing is, it's already out there, it's of public interest. That's why he doesn't have a case.
In any way, can Jason Pierre-Paul hope that something positive can he get? It's not much in damages, right? There's not much that he can...
You know, again, maybe a nuisance settlement or something, but he does not have a good case.
All right, I'm going to get to our third one. This has to do another NFL situation. Tony Romo's National Fantasy Football Convention has been canceled, and the NFL has won 1 round in the courts. A judge dismissed the tortious interference claim that Romo's company filed against the NFL. The group claimed the NFL wrongly contacted players and agents through the NFLPA. The conference was scheduled to happen at the Venetian in Las Vegas in March. The NFL saying, well, that's gambling, and we're not around gambling. We don't want that around our sport. Is the NFL going to win this situation? He just wants to play fantasy football.
The NFL is going to win because what they're saying is, look, we don't want our players being involved with fantasy football. Look what the attorney generals are doing in different states. This is a problem now. We want to be nice and clean. We don't want our guys associated with it. If that adversely affects somebody's business interest, so be it, but they can't expose their players like that.
About 25 seconds. Isn't there a difference between fantasy football and daily fantasy, though? Can't they just say, listen, we want to do the weekly fantasy, no big deal? Or is it all gambling to them?
Here's the problem. Why have to make that argument? Keep yourself out of harm's way. That's what they're doing.
That'll do it. Sports and the Law. Steve Moskowitz, each and every week right here. Thank you very much,
Always a
Stephen.
pleasure.
We appreciate it. Feldy Fareed, raring to go. Sportsnet Central on the way. Thanks for watching. Good night, everyone.